Judicial decisions undermining and weakening antitrust laws have undermined confidence in the integrity of the judiciary. Congress very clearly has always intended for aggressive enforcement of antitrust laws, but court-grafted rules and pleading standards have made the antitrust laws extremely difficult to enforce. Think about this. 5 corporations control 80% of the U.S. media market. Airlines merged from 12 major carriers in 1980 to 4. There are only 4 major carriers left. 4 giant companies control 80% of meat processing. Do you want to know why your meat is so expensive? They exercise monopoly power. Only a handful of companies control the pharmaceutical industry, and their patent rights allow them to exercise monopoly pricing. In every industry, there is substantial evidence of corporate concentration. Just the other day, courts let Facebook off the hook for its various acquisitions of Instagram and so forth, and held that Facebook is not a monopoly. I don't understand it. Facebook is clearly an entity with monopoly power. The courts have made it impossible to enforce the antitrust laws with ridiculous pleading standards and with standards of proof that are almost impossible for plaintiffs or the FTC or the Justice Department to meet. For example, you almost have to have a smoking gun at the pleading stage to withstand a motion to dismiss. And fundamentally, the biggest change of all is that back in the 1940s and even the 1950s, many types of antitrust violations, such as price fixing, vertical integration, exclusive dealing, were subject to what was called a per se rule. They were almost automatically illegal. Illegal tying was per se illegal, tying one product to another. Tie-outs were illegal. Price fixing, of course, was illegal. Now, what we have is a movement from the 1990s with Judge Bork and others away from per se rules to what's called the rule of reason. And in every antitrust case, instead of applying a per se rule to break up corporate dominance in any industry, the courts apply a rule of reason. And somehow or another, they almost always find that the pro-competitive effects outweigh the anti-competitive effects. And usually those findings are dead wrong. The shift away from per se violations or strict liability to rule of reason analysis has really made it impossible to aggressively enforce the antitrust laws. Ultimately, Congress needs to step in and control the judiciary in this area, because the main reason that your prices are so high is that we have monopoly concentration in almost every industry. And the prices are high and they keep going up because corporations have no competition with each other to drive prices down. The purpose of the antitrust laws has always been to pursue competition, because everybody understands that competition results in lower prices and is in the interest of the consumers. It's time for Congress to step up and enforce the antitrust laws. And here's the interesting thing. This is not a liberal or conservative issue. In fact, conservatives for years in many industries have advocated strict enforcement of the antitrust laws. I think Donald Trump has indicated that he'd like to enforce the antitrust laws against the pharmaceutical industry, the insurance industry, and the food industry. This is on one area in which I have an agreement with Donald Trump and conservatives. We need to aggressively enforce the antitrust laws to undermine outrageous levels of corporate concentration that occur in almost every industry.